Good afternoon, everyone. Just give me a minute. All right. I think we're just going to speak from here instead of going down to the dais every time. Since this is the ICC YAF, the Young Arbitrators Forum, and there are a lot of young practitioners here, students here, teams who are taking part in the WIS pre-moot, and eventually WIS moots East and Vienna. We hope to make this session as interactive as possible, as interactive as you guys are keen to make it. The pattern we're going to adopt is I'm going to just make some introductory remarks, set the pace as the moderator. We'll have the panelists bring up issues in their jurisdictions, and Alexander is just going to talk about the basic principles which underline joinder of non-signatories to an arbitration process. After each speaker, we would take about 5 minutes to discuss what they have presented on. At that point, you are free to ask some questions, and you're also free to ask questions whenever you want to. Just raise your hands and we would give you time, because that's the idea. We'll end with concluding remarks, just summarizing what we've discussed today. Now, just to give a bit of flavor as to what the basis of law is for joinder of non-signatories. Most of you are taking part in this moot, I suppose, so you would have done your research and be pretty up on what the basis of law is. But just to summarize it for some of you who might not be aware, the ancestral model law itself, which has been adopted by various countries as a part of their arbitration legislation, defines what an arbitration agreement is. An arbitration agreement, one of the conditions, but in the original 85 ancestral model law, was that it must be in writing, and there were certain parameters set around what the writing requirement of an arbitration agreement is, which were more inclusive and indicatory rather than conclusive and exhaustive. Could you just switch over to the next slide, please? Thank you. But this was 85. In 2010, Ancestral revised its model law, and Ancestral provided for two options to the definition of arbitration agreement. And what they did in the second, in option 2, is basically say that it has to be an agreement between the parties. That's about it. They did not go about defining this writing requirement and the non-exhaustive list. Why was this? Obviously, this was because commercial necessities pushed the arbitration community to evolve arbitration process itself. It became a commercial necessity to have non-signatories at times be involved. As Justice Swatantra Kumar pointed out, a phrase, and it stuck in my head, and I think it's such a beautiful phrase. A party cannot be allowed to have its contract and get out of it as well, right? So you can't benefit from a contract and at the appropriate time just step out, right? So that was the basis. In fact, I would just like to highlight a judgment of the Singapore High Court in the case of Aloe Vera America. And this is a phrase which I find as such a pertinent pointer of summarizing the ancestral model law. If you just go back the slide, please. Thank you. So paragraph 1, where the arbitration agreement is defined, and subsequent paragraph is the peripheral, the scope of what the written agreement would be. So the judge in that case says, in the context of ancestral model law, paragraph 1 requires a written agreement, but it does not require a signature. As to para 2, it is only illustrative and inclusive clause, and not an exhaustive list of what constitutes an agreement in writing. Now, another point to note from ancestral model law is that the model law or the legislations that have adopted model law do not provide the basis for arbitral tribunals to include non-signatories to a commercial arbitration process. Where they derive this power from, and again, this is to bear in mind that ancestral model law was drafted in 1985, and institutional rules came subsequently. So the ancestral model law only provided for this requirement of arbitration agreement and provided the tribunal with the principle of competence. That means the tribunal can rule on its own jurisdiction. And that concept had been widened quite a bit for arbitral tribunals then to include non-signatories into arbitration agreements. And then it was actually the institutional rules, which Abhinav will go into for ICC, and some other institutional rules, which provided the tribunal with this power. What is pertinent to note is most of these institutions, although provide the power to the tribunal to include a non-signatory, but there is a requirement still for an agreement of some form, of the parties to agree or submit to the jurisdiction of the tribunal. What stands out is the Swiss rules. I don't know how many of you all have dealt with it. I haven't dealt with the Swiss rules personally, but it stands out because it gives complete freedom to the parties, to the tribunal to hear the parties and decide on the circumstances, whether to include a party or not. Now, talking of rules, I'll hand this discussion over to Abhinav to make a presentation on the ICC rules on inclusion of non-signatories.
Right, just before I get into Article 7 and 29, and although I'll try to make it not very technical, let me just give you a very quick background on what institutions do, what at the ICC do we do, in particular what I do, specifically in relation to the emergency arbitrator provisions and the joinder of parties. We at the ICC, we have 9 teams and we administer cases which arise out of different jurisdictions, which have an ICC clause as the dispute resolution clause in the contract. 7 teams are based at the ICC Secretariat in Paris, 1 team is in Hong Kong, and 1 team is in New York. So I guess we are the only institution which administers cases from 3 different time zones, New York, Paris, and Hong Kong, which makes it very exciting to work on different cases coming from different parts of the world. Now, specifically speaking, this year's moot problem is based on 2 major issues: the joinder of a non-signatory and the emergency arbitrator. And the ICC rules of arbitration, which provide for these 2 aspects of the problem, is Article 7, which takes care of the joinder, and Article 29 and Appendix 5, which is the emergency arbitrator provisions. I'm going to also tell you about what we've seen and the experience we've had with the joinder, the issues that we have, and how closely they're related to this year's problem. So it's, in fact, when this problem was being drafted, the ICC was consulted, and Christopher Key and the others who drafted the problem were in touch with us, and we had a great role to play in the draft of the problem. ICC also is one of the stakeholders in the moot every year and sponsors the moot every year. And this year we are at NLU trying to organize one with all you guys. So one thing about what Justice Swatantha Kumar also said about interim measures, of course, no institutional rule, whether it's the ICC or any other rule, takes away the power to go to the court for an interim measure, for an urgent interim measure. Even if you have an emergency arbitrator clause, I mean, of course it needs to be interpreted in the way it needs to be interpreted. You always have the recourse under Article 29(7) to go to the court that you wish to go to. The good thing about, or unlike other institutions where there is no time bar as to the contracts, as to when you can apply for an emergency arbitrator, at the ICC we only administer cases where the contract has been entered into after 2012. Then you can ask for an emergency arbitrator. Also, the ICC standard clause is very clear that you have to basically opt out of the emergency arbitrator. If you've not opted out of an emergency arbitrator, then basically you've opted in. So it's an automatic opt-in. The filing fee, which is because since we've had 15 emergency arbitrator requests at the ICC so far, and fascinating issues, all of them, each one of them. The filing fee is, of course, $40,000, of which we keep 10. We give the emergency arbitrator $30,000. Just a second, yes. The sectors, oil and gas, mergers and acquisitions, real estate, telecommunication, the amount in dispute has been from $500,000 to almost, I think the highest one we had was $47 million. of one of the 15. There were two challenges against emergency arbitrators in one of those 15 cases, and both of them were rejected by the court. There were two requests where the parties made a request for the modification of the order, like we have in this moots problem. However, both were rejected by the emergency arbitrator. The request was made to the emergency arbitrator and not to the tribunal. So that's the difference here. In two cases, the president of the ICC court declared that this is not admissible because the contracts were entered into before 2012. One case was withdrawn, and in one case, one party filed a counterclaim, which was a question of admissibility or not. It was ultimately not administered. So this is a general overview on the emergency arbitrator provisions, and there are fascinating issues in this problem, which I don't want to reveal too much because you have to argue it out, and you argue it on Saturday and Sundays. And there are some questions that really don't have a direct answer, even within the rules or outside the rules. But yes, I mean, there is a position that will come through in the course of the arguments. Vis-a-vis joinder. Now, joinder is another very, very interesting thing that we see every day. I personally have administered about 25 cases where an additional party has been joined after the request of arbitration was filed. And there are various permutations and combinations as parties take. Sometimes they file a second request for arbitration. Sometimes they don't file a request for joinder. And then they say, okay, then I'll consolidate these two arbitrations. That's one way of getting another party into the arbitration. The other, I would say, an easier route under ICC rules of arbitration is the automatic joinder under Article 7, where the requirements of a joinder are identical to the requirements of filing the request for arbitration. One important thing is that you must have a claim. A real claim, a tangible claim. Even if it's an intangible claim, but there must be a claim. In some, you can identify that the party that is being joined, there is a claim against that additional party. And the issue is always about either a subsidiary is joining the parent company or the parent company is joining the subsidiary. And the argument is always that I am not the signatory and I was not a part of this. And the argument then goes back to the affiliates and who are the parties and the definitions. And then they say, oh, the arbitration clause is inseparable, is separable, therefore, there's no privity. I mean, this has been going on. I have seen this at the ICC day in and day out. We do, of course, if there are jurisdictional objections to a joinder. The ICC, under Article 6, does a prima facie review of those objections. We see whether, in the first instance, can we let this go to the tribunal? And like Akshay was mentioning, I mean, there needs to be something for the tribunal to decide whether this party can be a true party to the arbitration or not. As far as we are concerned, we look into it we call it prima facie, but we look into it for as much as possible without overstepping on the powers of the tribunal. We look at it, the ICC court looks at it. I'm one of those people who draft the agenda, who says this one was the signatory, this is the parent company, or he's a guarantor. In fact, my intern, former intern, Utkarsh, is sitting here, is the only intern. He had the benefit of doing that once. So these are these fascinating issues of like joinder and emergency arbitration and these interim reliefs that we see at the ICC every day. And one of the very interesting matter that I'm currently dealing with, I will not say much about it, is that there was an assignment agreement. I'm giving a live example where the parent company assigned all its rights to the Indian subsidiary. And the Indian subsidiary then entered into the contract with the Indian respondent. Then there was a breach of a contract. The Indian subsidiary filed a request for arbitration, made the Indian respondent a party to the arbitration. Of course, the Indian respondent went to the court, got an anti-arbitration injunction. Then the party joined the parent company under Article 7 of the rules. And the respondent company made the argument that after assignment, there is no arbitration clause between the respondent company and the parent company. Now this will, of course, we will, from the ICC's perspective, there's an arbitration clause, there's an assignment, everything is gone. There are certain provisions of the contract which allows us to let this matter go, and the tribunal will ultimately take a call whether this parent company can be a party to this arbitration or not. So with that sort of a brief background, I know we're already running late, so I'm not going to say much now, but I would expect questions if you have any that will able to tell me a little more about particular aspects. Try not to ask me a direct question of the moot problem. If you do, I'll try to answer it as best as I can. But with that, I will probably give it to Akshay or questions.
Thanks, Abhinav. Before we set up on questions from audience, and what we're doing is after every speaker, we're allotting 5 minutes. So that we can discuss the issues raised in the speaker's presentation, except for Singapore and Hong Kong, because that is the hotly debated, diametrically opposite views of Astro-Lipo between Hong Kong and Singapore. So that what we'll do is we'll let both the speakers finish talking, and then we'll do a 10-minute session on Singapore-Hong Kong issues. But Abhinav, on joinder of parties, Article 7, ICC rules provide that no parties can be joined after a tribunal has been established.
Are you asking me this question?
Yes,
yes, I think it's a very interesting question, and I think a lot of students have already asked me this question in the pre-moot rounds. So I think, so the question is that how can you join a party after the tribunal has been formed? And I think the answer...
Exactly, and that actually happens. I mean, it's not foregone, because in practical world, there are sometimes a hindsight. I mean, just before the statement of claim, at least, parties could be joined. So why this view from the ICC, and how does ICC deal with it?
Funny enough, this is something that has not happened in real case so far. But I understand that it is possible under the rules, because the term arbitral tribunal is defined, whether it's a sole arbitrator or arbitral tribunal. So the way we understand it is that the emergency arbitrator is not the arbitral tribunal under the rules. And therefore, he's the man standing before the arbitral tribunal was formed. He's an emergency arbitrator, which is in its own term not really defined. But yes, the rules make reference to the emergency arbitrator. But the term tribunal under Article 2 of the rules, 2.1 to be precise, arbitral tribunal includes one or more arbitrators, but that does not include the emergency arbitrator. So that's the answer to that.
But my question was actually slightly more pointed to the words, no additional party, this is Article 7.1, no additional party may be joined after the confirmation or appointment of any arbitrator, unless all parties, including the additional party, otherwise agree.
Correct.
Whereas there is an exception made that before the arbitrator is appointed, ICC would look into it straight away, and there needs to be no agreement issue at that point.
Right.
Isn't this distinction some kind of, I mean, it's mere procedural, doesn't it?
It is, but here's the thing, because before, the question is as to why this distinction is there, because sometimes what happens is, and that's a very important question again, is that before the tribunal is formed, or is confirmed, an arbitrator is confirmed, every party should have a say in the appointment or the confirmation of that arbitrator, because of the principles of natural justice. Now, if I have already confirmed an arbitrator, and a third party has joined, there can be a conflict of interest. If the interests are aligned and the parties may not agree to that appointed or confirmed arbitrator, which is why the distinction is very important, that before confirmation and after confirmation. After confirmation can only happen if everybody is on board. But before confirmation, yes, you can join in a party. The ICC rules do not have a problem with that. We had a case where they tried to join after the constitution of the tribunal, and the party said, I don't agree to this tribunal, but the tribunal is already appointed. So that's the problem there.
I think in situations like that, the tribunal will have to agree as well.
Yes.
Any other views from the panelists? Any queries not relating to the problem directly? No? All right, great. So next we're going to move on to Alexander, who's going to present on some of the theories that have been propounded, or I think evolved would be an appropriate term, because these have really evolved over time, these theories, to include non-signatories, generally being theories like piercing of corporate veil, alter ego agency, so on and so forth. Alexander, floor is yours.
Thank you. I'd like to say this is my first time in Delhi. I'm delighted to be here. Perhaps you may be interested to hear that I'm Austrian. I'm from Vienna, but I practice as an English lawyer in Dubai. I have been attending the moot for the past 10 or 12 years as an arbitrator. I've been enjoying it thoroughly, and I hope that whoever will come, and I guess a large part of this audience, will also enjoy that experience in Vienna and my hometown of Vienna. Complicated commercial transactions or projects require the participation of several parties. Now, I will give you an overview of the legal theories or scenarios for binding non-signatories to international arbitration agreements. Arbitration is fundamentally consensual. Typically, the parties to an arbitration agreement will be its formal signatory. Nonetheless, there are a number of legal bases by which non-signatories may be held to be parties to an arbitration agreement. The issue is one of the most complex issues in international arbitration. As a main principle, arbitration agreements are binding on parties only and not on others. Now, the principle is a straightforward application of the doctrine of privity of contract, which both civil and common law jurisdictions recognize. In some legal systems, for example, Switzerland, the identity of the parties to an arbitration agreement is referred to as a question of the subjective scope of the arbitration agreement or jurisdiction, which is called ratione personae. In others, for example, the United States and Singapore, the identity of the parties to the arbitration agreement is characterized as a question of formation or existence of the agreement to arbitrate. In any event, what all jurisdictions have in common is that only the parties to the arbitration agreement shall be bound or benefit by that agreement. This principle is, of course, recognized by several conventions. Article 2(1) of the New York Convention impliedly recognizes the subjective limits on the binding nature of arbitration agreements. Contracting states shall recognize an agreement in writing under which the parties undertake to submit their disputes to arbitration. The model law defines an arbitration agreement as an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them. Even in the absence of statutory provisions to this effect, settled law in all developed jurisdictions provides that it is the parties to an arbitration agreement and not anyone else that shall be bound by the agreement. Similarly, to give you a recent example of 2010, the English Supreme Court concluded in the famous Dalla matter, the validity of the arbitration agreement depends in the present case upon whether there existed between Dalla and the government of Pakistan any relevant arbitration agreement at all. Now, institutional rules obviously uniformly assume that only parties to an arbitration agreement are bound by that agreement. Now, in the vast majority of cases, the way to determine the parties to an arbitration clause is simply to look at the signature page or the recitals of the contract and see what entities are designated there. Despite this, the party that executes a contract is not necessarily a party to either that agreement or the arbitration clause associated with it. Under most legal systems, an agent or representative may execute an agreement on behalf of its principal, producing the result that the principal is a party to the agreement. But the agent or representative is not. The most obvious and frequent application of this rule is when agreements are executed on behalf of corporate or other legal entities by their officers or agents, with the result that the corporate or other legal entity is a party to the agreement, but the officer or agent, in his or her personal capacity, is not a party. It is also clear that entities that have not formally executed an arbitration agreement or the underlying contract containing an arbitration clause may nonetheless be bound by the agreement to arbitrate. Notwithstanding their status as non-signatories, there are circumstances in which entities that have not signed or assented to an arbitration agreement may be bound and benefit by its terms. To determine when a non-signatory is bound or benefited by an international arbitration agreement, typically requires the application of general principles of contract law, agency, and corporate law principles. Now, there are virtually in all instances no conventions or national arbitration legislation that provide guidance in identifying the parties to an arbitration agreement. Instead, disputes over the identities of the parties to international agreements and the application of non-signatory doctrines have been left almost entirely to national courts, arbitral tribunals, and commentary. For the most part, these authorities have indeed applied generally applicable principles of contract, agency, corporate law to resolve such non-signatory disputes. Now, national courts and arbitral tribunals, they rely on a variety of legal theories to bind entities that have not executed an arbitration agreement. These theories are in most cases based on generally applicable rules of contract and commercial law, including rules of agency, alter ego, implied consent, group of companies, estoppel, third-party beneficiary, guarantor, subrogation, legal succession, and ratification or assumption theories. In each of these instances, non-signatories of a contract can be bound by and may invoke the arbitration clause contained within it. I will run through and tell you a bit more about these theories in a minute. Although analysis may differ, what all these theories have in common is that in all cases, the inquiry is whether particular facts satisfy applicable legal standards for either establishing consent to an agreement to arbitrate or on a non-consensual basis for binding an entity to the agreement. The focus in many cases is on the parties' intentions. In particular, the focus is on the parties' intentions, actual or presumed, that their arbitration agreement will accomplish the purposes for which such agreement is designed. In some non-signatory contexts, however, that focus is not limited to issues of consent. Rather, in a few instances, applicable law will subject an entity to an arbitration agreement even if it did not consent or even intends to be bound by that agreement. This result is mandated by the force of law and considerations of equity, typically under theories of piercing the corporate veil, alter ego, estoppel, apparent authority, or succession. Now I'll go through various legal theories and give you a flavor how they evolved. The simplest, least controversial circumstance in which a non-signatory will be bound by an arbitration agreement is when an agent executes a contract on behalf of its principal. It is well settled under all developed legal systems that one party, an agent or similar representative, may in certain circumstances legally bind another party, a principal, by its acts. Among other things, an agent may execute contracts, including arbitration agreements, which will be legally binding on the principal, although not necessarily on the agent. For the most part, courts and arbitral tribunals have relied on generally applicable principles of agency law when considering questions of agency in the specific context of international arbitration agreements. I'm being told I have 5 minutes left. That's interesting. Okay.
Since we've already overshot the time.
Right. Can I get 10 minutes?
Nah, 5. That's it.
Okay. So while the, for example, to give an example on the court, the Swiss Federal Tribunal annulled an award on the application of one of the states, reasoning that there was insufficient evidence. Hang on. Yeah, that the state had granted international organization power to bind the state on arbitration agreements. So it was said the arbitration clause cannot be opposed to a party which did not sign it, unless this party is nevertheless bound by the clause by the signature of an entity or third party empowered to act on behalf of the first party, on the basis of an act granting to that entity or third party the power to refer a dispute to arbitration. Now, another theory is the apparent or ostensible authority. Now, under the apparent authority theory, a party may be bound by another entity's acts purportedly entered into on its behalf, even where those acts were unauthorized, if the putative principle created the appearance of authorization through words or conduct, leading a counterparty reasonably to believe that authorization actually existed. In particular, this theory of apparent authority can bind the apparent principle to a contract, including an arbitration agreement entered into on its behalf by the apparent agent. This doctrine rests in part on principles of contract law and good faith. Implied consent, another theory. It is not only by formal execution of an agreement as a specifically identified contractual party that an entity can become a party to that agreement. In the most developed legal systems, an entity may become a party to a contract, including an arbitration agreement, implied, typically either by conduct or non-explicit declarations, as well as by express agreement or formal execution of an agreement. For example, where a party conducts itself as if it were a party to a commercial contract by playing a substantial role in negotiations and or performance of the contract, it may be held to have impliedly consented to be bound by the contract. Alter ego and piercing the corporate veil. Now, authorities from virtually all jurisdictions hold that a party who has not assented to a contract containing an arbitration clause may nonetheless be bound by the clause if that party is an alter ego of an entity that did execute or was otherwise party to the agreement. This is a significant but exceptional departure from the fundamental principle that each company in a group of companies, a relatively modern concept, is a separate legal entity possessed of separate rights and liabilities. In many English language contexts, it is called piercing or lifting the corporate veil. The International Court of Justice, and is important, explains the veil-piercing doctrine in a case called Barcelona Tractions as follows. The process of lifting the corporate veil or disregarding the legal entity has been found justified and equitable in certain circumstances or for certain purposes. The wealth of practice already accumulated on the subject in municipal law indicates that the veil is lifted, for instance, to prevent misuse of the privileges of legal personality, as is in certain cases of fraud or malfeasance, to protect third persons such as creditor or purchaser, or to prevent the evasion of legal requirements or of obligations. Another theory is then the group of companies doctrine, which is highly controversial. It is a basis for finding non-signatories to an arbitration agreement under a sort of group of companies doctrine. Under this principle, non-signatories of a contract may be deemed parties to the associated arbitration clause based on factors that are often roughly comparable to those relevant to an alter ego analysis, particularly where a company is part of a corporate group, is subject to the control of or controls a corporate affiliate that has executed a contract and is involved in the negotiation or performance of that contract, then that company may, in some circumstances, invoke or be subjected to an arbitration clause contained in that contract, notwithstanding the fact that it has not executed the contract itself. I'll drop all of this. And a very important case here was a French case. It was the Dow Chemical France case. Now, I need to skip this. Third-party beneficiaries are another issue.
No pressure.
Thank you. In some legal systems, non-parties to a contract may, in certain circumstances, claim the benefits of that contract as a third-party beneficiary. For example, England, Australia, Ireland, and Austria, Denmark, France, and India. In such circumstances, the third party may either be able to invoke or may be bound by an arbitration clause in the contract. That said, the parties' intentions regarding a third-party beneficiary should be analyzed. In determining whether a third party is benefited by an arbitration agreement, the decisive issue is whether the signatories intended to confer that benefit on the third party. In addition, however, a third party may be bound by an arbitration agreement if it asserts rights that it enjoys by virtue of its status as a third party beneficiary to a contract containing an arbitration agreement. In these instances, the relevant intentions of the signatories will focus on the underlying contractual rights as distinguished from the arbitration agreement. Some courts have required that the third party be entitled to and assert contractual rights as distinguished from limitations of liability on their contract in order to be subject to its arbitration clause. Another concept and theory is guarantors. It is not uncommon in international commercial transaction for one party to guarantee the obligation of another party under a contract to which the guarantor is not party. When this occurs, questions may arise as to the extent to which the guarantor is bound by provisions of the underlying contract, including in particular its arbitration clause. Now, another theory is called succession. It is well settled that an entity that does not execute an arbitration agreement may become a party thereto by way of legal succession. The most common means of such succession was by a company's merger or combination with the original party to an agreement. Most national laws provide that the merged or surviving entity succeeds by operation of law as a party to the contracts, including the arbitration agreements of the previously existing entities. Most authorities have held that the national law governing the issue of succession also applies to non-signatory succession to an arbitration agreement. Now, there's also a theory of assignment and other transfer of contractual rights. I will skip this a bit because it was referred to in the keynote. Another theory is subrogation. Under many national legal systems, there are circumstances where one party may be subrogated to the contractual rights of another party. This frequently occurs in the case of insurers who are subrogated to the rights of insurers. In these circumstances, the insurer is typically entitled to invoke and is bound by the arbitration provisions of the insurer's underlying contract, from which the subrogated rights arise. Estoppel and related doctrines. I suppose you will all be familiar with estoppel from Indian law, so I will skip it. Ratification. A non-signatory and non-party to an agreement may subsequently become a party to the agreement by ratification. Ratification can occur with regards to arbitration agreements as well as with other forms of commercial contracts. Now, for example, if Party A to an arbitration agreement may ratify Party B's assignment of Party B's rights and duties under the arbitration agreement to a third party. Likewise, in the case of novation, a similar concept, a new contract generally replaces a previous contract and one of the original parties is substituted by a new party. There are also issues in theories in relation to corporate officers and directors when they sign agreements on behalf of their companies. There's also a theory about shareholder derivative rights, in particular in the United States. A particular issue is the state non-signatory, but I haven't got enough time to tell you more about it. So it remains to say that these are basically the most common multi-party scenarios and theories. I hope this gave you a flavor of the complexities involved. And as a final remark, I would say that, as I said at the outset of my presentation, all arbitration is based on consent. Hence, any justifiable theory of multi-party scenarios must be consistent with the evidence of consent in the instant case, whether it is subjective consent proven by objective features or whether purely objective consent is the required factor. Thank you for your attention.